Good afternoon and welcome. The market is currently focused on this SRT structures, regulatory capital relief, and synthetic risk transfer. But regulatory risk transfer is not the same thing as value realization. In distressed situations, the real question is not whether exposure has been transferred on paper. The real question is whether the structure can actually deliver a credible, enforceable, and value-maximizing exit under stress. In our view, any resilient recovery structure should therefore contemplate enforcement through a public auction process, because a properly conducted public auction is fast, transparent, clearly governed by statutory law, legally robust, court-defensible, and capable of maximizing value through a competitive bidding process. Today, I want to discuss why governance, enforcement control, and intercreditor execution risk remain critical issues in cash SRT structures, particularly when restructuring pressure and recovery execution begin to diverge. Because at the end of every structure, every intercreditor arrangement, and every synthetic transfer mechanism, there still has to be a real-world enforcement and value realization process. And that is exactly where governance conflicts, control issues, and enforcement risks begin to surface. Regulatory risk transfer is not synonymous with value realization. In stressed or enforcement-driven scenarios, many cash SRT structures reveal a fundamental disconnect between regulatory capital treatment, actual control over collateral enforcement, and the economic recoverability of value. In this video, we examine the governance, enforcement, and intercreditor risks embedded in complex cash SRT arrangements, particularly where legal control rights, disposal authority, and restructuring dynamics begin to diverge under distress. Significant risk transfer (SRT) transactions have become a key instrument of regulatory capital management for banks. Their purpose is to transfer credit risk to third parties to an extent that allows capital relief under the Capital Requirements Regulation (CRR). The decisive factor is not merely the legal form of the transaction, but the regulatory recognition that a substantial portion of the credit risk has effectively left the bank's balance sheet. In cash SRT structures, this transfer is typically achieved through a true sale of a loan portfolio to a special purpose vehicle, SPV, which finances the acquisition by issuing asset-backed securities, ABS, to investors. Depending on the trade structure, investors assume the credit risk of the underlying portfolio, while the originating bank achieves capital relief without necessarily relinquishing servicing or client relationships. The growing use of such structures across Europe reflects the increasing importance of balance sheet efficiency and capital optimization. Cash SRT transactions combine funding benefits with regulatory relief and are often implemented on existing ABS platforms. In many cases, transactions are also structured to meet STS requirements, although STS status and SRT recognition remain legally distinct exercises. Despite their efficiency, cash SRT structures primarily address a regulatory objective. They do not answer the question of how value is actually realized in a recovery or enforcement scenario. This distinction is frequently underestimated. Pricing in SRT structures is inherently model-driven. It is based on assumptions regarding default probabilities, loss given default, correlations, and macroeconomic scenarios, as well as on the structural allocation of risk across tranches. Investors price these risks based on such models and their own expectations. The resulting valuation reflects market sentiment and structural parameters, but not a price established through an actual recovery process. In other words, SRT structures provide valuation under assumptions, but not an empirically validated recovery value. This distinction becomes particularly relevant in stressed or distressed situations. As portfolio performance deteriorates, model-based valuations lose relevance, and the decisive factor becomes the actual willingness of third parties to transact in a real recovery setting. It is precisely at this point that often overlooked governance risks arise within intercreditor structures. In syndicated financings and structured credit arrangements, enforcement decisions are typically taken by a security agent acting on behalf of the creditor group. Intercreditor agreements usually define voting thresholds, ranking, and decision-making mechanics, but often provide only limited guidance on the actual execution of enforcement and the methodology of value realization. This creates a structural tension. While ex-ante valuation and risk transfer within SRT structures are model-based, enforcement requires a concrete decision on how assets are to be realized. In the absence of a clearly defined, legally robust and market-validating mechanism, enforcement decisions may become vulnerable to challenge, whether by subordinated creditors, debtors, or in an insolvency context. For the security agent, this translates into a distinct liability and governance risk. The agent must ensure that the chosen enforcement route is not only commercially reasonable, but also legally defensible. Without a recognized and structured recovery mechanism, the agent may face allegations of insufficient market testing, inadequate price discovery, or breach of fiduciary or contractual duties. Against this background, public auctions take on a distinct role as a reference mechanism. They are not funding tools, but legally established enforcement procedures designed to generate a market price through open competition. They enhance transparency and significantly reduce the risk of subsequent challenges, as they rely on a formalized and widely accepted process. German case law, including decisions of the Federal Court of Justice, confirms the robustness and enforceability of such mechanisms. From an intercreditor perspective, this implies a necessary evolution in transaction design. It is no longer sufficient to define voting mechanics and ranking structures in abstract terms. Equally important is the definition of how value is to be realized in a recovery scenario and which mechanisms ensure that the resulting price can withstand legal and economic scrutiny. Embedding a structured enforcement mechanism has stabilizing effects across the transaction. It provides clarity to all stakeholders, reduces conflicts between creditor classes, and strengthens the position of the security agent, who can rely on a recognized process when exercising enforcement discretion. The appropriate framework is therefore not to view SRT and enforcement as alternatives, but as complementary components. Cash-SAR operates ex-ante by delivering capital relief and balance sheet optimization. A robust enforcement mechanism, ideally based on a transparent and legally recognized auction process, ensures that value is actually realized in a recovery scenario. For lenders, security agents, and investors, the conclusion is clear. A resilient structure must address not only regulatory capital requirements, but also the governance and execution of recovery. Regulatory risk transfer solves a capital problem. Enforcement solves the governance and recovery problem. Only the combination of both, together with a transparent and legally robust public auction exit mechanism, creates a resilient, defensible, and value-maximizing structure. Thank you very much for your attention. If you would like to discuss enforcement structures, public auction solutions, intercreditor governance, or distress recovery execution in greater detail, please feel free to contact us directly. We look forward to continuing the discussion.